Message. Are you coming this morning? Michael asked me. Do I have, I'm going to say, do I have a choice? Question, do I have, you think he'll think that's funny?
Okay, very good. Okay. All right. Thank you. She said she's gonna meet you at the house tomorrow. Yeah. I don't know. Yeah, it's been working all day. What time do you need it? But it's all right.
Good morning, sir. We'll just wait for people.
I'm well. You?
You know.
I hope there's a
well-known thought. Just too much going on.
Yeah, you'll imagine. I learned one joke.
So somebody at the lake is selling in the lake, and the HOA says you have some trees violating. And the sellers live it, wants to talk to me about whether they have a right to call this a violation or not. It's the LMOA. It doesn't really matter if they have a right. They're going to do it. You're going to need to fix it.
Good morning. How are you? I don't know if we follow that. Maybe we have some income costs.
Oh, hey Dan, I'm Justine Nix.
Yeah. I have actually military.
I know. We have.
Okay, good.
Reaffirmation.
Yeah. Are you related? Hi. Are you related to Alex? He's my brother-in-law. Oh, he is.
That's right.
Okay, I figured somehow. Yeah. Yeah. He ran in. Yeah.
My husband and I had ACAC the other night.
Yeah. You should be down there.
Waiting for, I guess, some more people. I'll see what I have. What she gave me. I was in a seminar yesterday. I was hoping I learned something good in the seminar to tell you guys. Let's figure out what this one does. See what it is. Tips for agents who represent buying or selling. Let's see. We're going to go just theoretically start. So we're going to start. Yes. On TV. You're going to watch from your own. Hi, guys. All right, great start. Does anybody have anything they want to talk about? That's all right. So, here's a info sheet.
Why don't you do your see what?
Yeah, because if we don't have anything to go over, I just thought, this is the packet I was given. I was in a seminar yesterday hoping to learn something, but we go to these seminars about an annual seminar, what's new in real estate from the lawyer side. They talk about new legislation, case law. Then they do. Then they pick topics. And I couldn't figure out how this was ethics. We always have to have some ethics. And it was about cybersecurity. And these people were just talking over everybody's head. Even their slides were like, what? They just scared everybody in the room. But when I was listening to the case law and legislation, who cares about the Chesapeake Bay oysters? But somebody in Chesapeake Bay, but man, that was like a big topic that we had to learn about. And then in one of the counties, there was like one of the counties, there seems to be a lot of people dumping into the Chesapeake Bay, and so there's all legislation about that. Case laws about condemnation, just stuff that, I mean, I guess we're supposed to know as lawyers, but who cares?
Like some of the things we learned in the early real estate classes.
Uh-huh.
that we
No,
didn't
this is
use.
supposed to be advanced crap, and I'm just thinking, oh, what am I doing here? But the last guy was an estates and trust lawyer, sort of talking about elder people in real estate. So that was kind of interesting, but he was like, except for he kept walking off camera, as a video. He had a mic on, so he could walk, and the camera was stationary, so where'd he go? Except for that, he would have put us to sleep. But he had some, some interesting stuff about, which I didn't know. Well, I knew it, but I got to go talk to our elder care attorney. People, as they get older, they own real estate, and they may have paid for it by then, and they may have, Social Security and some kind of retirement. That's all they got. And so how do you protect that real estate for your heirs? Well, a lot of people decide to gift it. Let's gift it to the kids and get it out of our name, because if you go into assisted living and take Medicare on, or Medicaid, I never remember which is which, the one that takes care of assisted living, you can't have any assets. And so the elder care attorney, was talking about some of the potential tricks of how you can, keep that real estate or deal with that real estate so the kids have it and it's not going to be sold to pay for the nursing home. And so that was kind of interesting. What I always thought is you make a gift, and the Social Security or Medicaid, whoever does this, has a look back. And what that means is if you make a gift any time of an asset and you now want to get assistance, they're going to say, have you made any gifts in the last 5 years? That's the look back. So a lot of people make that gift earlier than they think they may be getting sick to go in the nursing home, so that they get past the 5-year look back. And that's sort of advice that we give all the time. Of course, when you give your house to your kids, you don't own the house anymore. So you hope your kids are going to treat you right. So then he said, well, you can retain a life estate. This I didn't know, and I got to check into it some more. You can retain a life estate, and I always thought if you had a life estate, that meant then when you went in the nursing home, you had an asset. That apparently, especially if you have a mortgage, your life estate has to take care of insurance and taxes and a mortgage, the interest part of the mortgage, not the principal part. So you can rent the house out, for example, and that income can pay for that. And then when you die, it belongs to the kids, and you've still kept some interest in the house and been able to maybe get around having Medicare, saying, hey, you still have a life estate. That's worth something. So I think that was interesting. And that did help you guys in real estate out a lot, because you want to sell the house when they're ready to sell it. That's just a mechanism not to sell it.
Does that kind of circle back though, if you're dealing with older people looking to sell their home, having conversation, understanding and asking the right questions in terms of ownership and or
Yeah, and even if you sell your house, then you now got you're going to get those assets, which most older people want to live on. But that's certainly a mechanism. One of the things they talked about regarding that was that if you if you sell your house, the current laws allow you to. We just start talking about nothing yet. I'm talking about elder care. You're talking about elder care, elder issues. So if you sell a house and it's your primary residence and you lived in it 2 out of the last 5 years, then you can deduct $250,000 of profit. So you don't have a pay tax on that $250,000. And if you're married, it's $500,000. So one of the this is again, the elder care attorney was talking about this. One of the mechanisms with people getting married later in life after the kids are all gone and their first spouse has died is if you can, like, let's say you were living in the house, wife passed away, you 2 years later have somebody you want to get married to, and now but she's got a house. Well, I don't know if you put her on the deed. I'm not sure about that. But if you sell the house and you're married and she's living in it, you get $500,000 to profit. Then you go live in her house. You can do it again after 2 years. So there's some kind of interesting things about that. So I guess that's probably a good time to make sure they consult a CPA about that. Such. Did you read my email?
I did
My
not.
response to you?
On my text?
Yeah, your text. I said, do I have a choice? We were just talking about, I was in a seminar yesterday that pretty much is worthless other than I keep my law license. But some of the issues that came up was elder law in real estate, just some of the potential issues with elder people and what they should do with real estate. Any other questions about that or just thoughts? Because we're always looking at, with the reverse mortgage, that's a great technique too to use. If you've got somebody who wants to stay in their house, but they need some extra income and they're going to stay there, you get a reverse mortgage. You all know what a reverse mortgage is. And, it costs extra to do it, and they just changed the law so you can't get as much equity out as you used to. But, it basically becomes a lien against the house. It doesn't have to get paid till you either die or vacate.
What are the downsides to this? I know Ray did it with his parents and it went great. But I also hear people that, find themselves at the end of the time frame and
There's a lot of good things about it, but usually credit is not as much. Credit used to be no issue at all. Now there is some credit issues, but not like a way of getting a regular loan. You got to have more equity because they don't loan 80% because interest is going to be accruing. It costs more to get that loan, so you're going to spend, if you've got a normal loan that's, let's say, $8,000, you're going to spend $15,000 to get a reverse mortgage because of some of the cost involved. But it's without recourse. What that means is, if you just say, you know what, I'm just not going to live here anymore, I'm not going to worry about it, you just leave, or you die and your kids now have it, your kids don't have to pay the mortgage if they don't want to keep the house. And so they can't come after anybody for that. So there's some good upsides. I mean, it's not for everybody.
that's what I'm asking. Who would it not be for?
Well, I think there's more an individual looking at their case, like I did. We do some reverse mortgages. Sometimes if you've got, here's a little technique that we used to do. If you've got 10 acres, house on 10 acres, go subdivide 8 acres off, and then do the reverse on the 2 acres in the house. So now they still got 8 acres to sell if they want to. So there's all kinds of little techniques that it's, if somebody has a 60, 70% mortgage, they're not going to get it. They may not be able to get a reverse, or if they do, they're not going to get any cash out. They're not going to be able to have an annuity or some, sometimes they treat them like a line of credit. You can just write checks against it. But you got to have some equity.
To the point of subdividing 10 acres as an example, would that be subject to visual rights?
Oh, sure. Yeah. But more than likely you can do it. You can do, and if you can't do it in a regular subdivision, you do a family subdivision. Usually that'll make it less stringent. Each county has their own rules. What that usually means is you can't, whoever you transfer the property to, they can't sell it. And you may not be able to sell the 2 acres with the house on it for a number of years. But except for that, it's got some great things. I did one once with my kids. I bought a house. It was just buying as a rental house, and it had 12 acres out off of Gilbert Station Road. And so, in the road to get to the 12 acres or the 10 acres in the back sort of came by the house. So I said, let's just do a family subdivision. And, I had to go perk the other lots and such. But so now I've got a house and then 2 acres, and then I've got 3 lots that belong to each of my kids. And I told them, you're gonna have to pay me back for what I spent. But now they, you know, I hardly owe anything on that Gilbert Station house, because I paid that mortgage almost off. And then I got these 3 lots that are, you know, worth $100,000 each or something. So it's, you know, for the kids, it's a great thing for them, you know, when and if I let them sell it.
Would that have to be sold as a family?
No, they're, all I would need to do is put a road maintenance agreement in. You know, I may have already done it.
Family divisions are used mainly when you don't have division rights remaining on the property.
Or it's too strict.
Yeah.
It's not that you don't have division rights, it's more, it's like you don't have frontage. You know, you gotta have so many feet to, in our county, 200 feet of frontage under the subdivision.
Well, even Roger Ray says that probably half of the undeveloped land in Albemarle County doesn't meet site distance requirements for the subdivision, which is
So,
more than half.
Well, again, what you're saying is that that family division can be flipped over when it's sold to basically someone buying it and sold.
well, back then when I did it, the restriction was none of the kids could sell their property for 2 years. Now Albemarle County, I think it's 5 years. And I believe it also limits my land. I can't sell my land. So you can't sell the parent tract or what you subdivide. But each county regulates it differently. But that's a great.
How long ago did you do it, Bill?
Excuse me?
How long ago did you do it?
Oh, gosh, 15 years ago.
Yeah, because I think some of the guidelines have changed since then. Since I came to Charlottesville in 05, I think they've tightened that.
Right, well, like I said, you can't, it's 5 years and you can't resell any of the parcels.
Right.
But then after you get past that 5 years, you can do whatever you want to with it. They can even deed it back to me. I mean, I can say, give me back the land. I'll sell it all as one parcel and keep all the profit. But you know, it's a great way to do some estate planning too. So anyway, since we didn't have any topics, what I handed out was.
Can I ask you a quick question? I had something come up today that I've never had before. Jerry's got a condo. Jerry Russell has a condo. And people have asked for a radon test. Now I'm guessing it's a townhouse condo. I've emailed her back and said, does it have a basement? But if there is radon, who's responsible for that? Because that's outside the 4 walls. Would you go to the condominium association to do remediation, or what would you do with it? I've never had that come up.
Yeah.
I have a client over at, over there by the Wyoming, what's the name of that place? It's
Walker Square?
Walker Square. And she had a ground floor condo, and her friend of hers wanted to buy it, did a radon test, had radon, so she had to mitigate.
The seller had to mitigate, even though it's underneath
That's right.
what is actually their ownership.
Mhm. I would, you know, I think you make an argument that the condo association is supposed to do, you know, take care of the property, and it is coming from outside the floor of the corn, you know, the skin of the condo. But if you want to sell it, you may have to remediate it, and I bet the association's not.
Yeah, I had a problem with that at Georgetown Green over here.
Those are townhouses.
Those are townhouses, but we had something with that. There was a mutual thing with the attic about putting the remediation unit in there. I remember it was a big, we had a big fuss over this. It took
Only
quite
the
a while.
firewalls, is that
The firewall.
they don't go all the way up.
Right, the firewall created this big thing, and it took us a while to work that out. It was.
So would the answer be that it's the seller's responsibility, that they get the condominium to do it? That's great, but
Yeah.
ultimately,
When you sell the house, you gotta satisfy the contract.
And it might be more expensive because of height,
right?
so just be, that's what I found.
Because you gotta get that air
Yeah.
out somewhere.
Yeah. I want to ask a couple of
So
questions.
what I gave you is, this is something I did a number of years ago, practice tips for realtors and representing the buyer, and there's one for representing the seller. So it's-
What legal descriptions always fascinate me when people come up with. And now, of course, our template we use allows you just minuscule amount of room, which is quite frustrating. But I go back to when we used to write our own contracts. There wasn't a form. And I always think that the deed book is the most important one to put down, or the lot and whatever. But sometimes pieces of land or properties don't have that. And the tax map is really not a legal designation.
Well, what I think the best thing is, if you can go get the deed in, the deed that your people bought the property, and look at that legal description, and if it gives you a lot and block number, use that.
Mm-hmm.
If it just says 40 acres and it may refer to a plat, then I would say 40 acres and refer to that plat. I would take the legal description, because that's what the people selling it bought it as.
Mm-hmm.
And that deed also lets you know their correct legal names for the contract. Because I always use me as an example. I'm Bill Tucker, but if I took title William D. III, that ought to be the way the contract's written. So getting that deed in, if you're the listener. But the first one's practice tips for representing a buyer. So, like the correct names, doesn't have to be the legal name, but it needs to be on that contract, whatever name that buyer wants to be known as for owning this real estate. So again, using me, if I wrote Bill Tucker in, I happen to, there are other Bill Tuckers around. So I would want on that contract to ask, the realtor asked me, well, what name do you want to be? And I probably want to be William D. Tucker III, because my son's the fourth. And let's not get fused. And so that name on that contract probably becomes the way I should apply for the loan. And that's the way I'm going to probably get the deed deeded to me. So you want to when you're representing that buyer, you want to say, hey, I don't need your legal name, but how do you want to take title? Because this is probably the way it's going to be all the way through the transaction. You'll be amazed the number of times. We get. I'm dealing with the John Smith now in Spotsylvania, and there are like 50 judgments against John Smith in Spotsylvania.
There've been a lot of John Smiths in Virginia over the years. That's right.
And the other thing is, make sure you get their name spelled right. I'm dealing with one right now. I got on my desk that said the name was some name with an L, could have been an I, and it was really hard to know what it was. And all the way through, everybody read it as an L, and it should have been an I. And so now we got to go back and correct everything. And of course, the buyer's sitting there signing stuff at the closing table, and they don't even catch it.
Yeah.
But
Michael's daughter, I had C for her middle initial and G, and all the way through 5 different contracts. No one caught it until the closing table.
So names are important. Number 2, this is, if you have questions, there are a lot of real estate attorneys who answer those for you. I don't mind doing it, especially if I end up getting the transaction, because I'd rather give you some language to put in the contract now to avoid that problem later on. If you have questions, if it's just filling in the blanks, you don't need me for that. And the contracts are really, I think, well written now, because they keep changing and we keep learning what they're changing. Number 3, ask the listing agent to see if the seller has prior title insurance and or a prior survey. That can be really helpful.
And save the money, right?
Save the buyer money and probably save some potential problems that may have existed in the past that don't need to be problems today. I'll explain that. Number 4, I guess that was your question about the correct legal description. We now seem to be getting involved. Number 5, we seem to be getting involved earlier in the process. That some lenders want to go ahead and they want to know figures for the loan estimator right off the top. I know some lenders want to know what the homeowner's insurance is going to be at the beginning. They want to put it down on the loan estimator. So the buyers now are got to do more than they normally used to do, just worry about signing a contract and getting it inspected. Sometimes you're being asked to do other stuff.
I recently represented the seller and the buyer had a special or an addendum addressing triad rules. I've never seen it.
I haven't either. Don't do it yet.
Well,
Well, early on, you have.
But that's right. There's, and it's still not been passed, at least the best I can tell. It is, you guys, everybody wants copies of the CD at the end. But it may be that it wasn't allowed that you could get copies. I think the practice is sort of rolled into where we get them out now. But there is some rules pending, maybe it's finally been passed, allowing this stuff to be shared. And so I had sent a tip out a long time ago, why don't you just stick it in a contract that we can share this information. It never took on, it never got many legs, but apparently we all worked around it because I very rarely, even when we're dealing with out-of-town people, have an issue where we have to, we can't share the CD. One thing about CDs in our community, when we're representing a buyer, most of the lenders now have decided they also need the seller's CD. There's a separate CD for a seller. And a lot of the lenders are now requiring the buyer's attorney to get the seller's CD figures and get them on the CD. Not all of the lenders are doing that. So we're getting more of the CDs going from one party to the other. And there's no hard and fast rules as to which way is right. I'm amazed the different times we will deal with a lender and we're told this is what TRID says. And we'll say, okay, I'm glad you guys think it says that because 99 other banks don't think it says that, but if you think it says that, we'll deal with it. We had one that usually the process is the lender at the beginning may ask us for some figures to fill out the loan estimator. Clearly, when we get time to do the CD, now we're ready to close, the lender's asking us for figures to complete with their figures. We had a bank in Madison. It was a branch, so we closed with this bank a lot, but this particular branch believed that we, the buyer's attorney, in order to send the CD out 3 days ahead of time, we had to send them the CD with our figures on it, which we knew we did. That's what the practice is. But then they said, no, that's not sufficient. You have to send us your CD with our figures on it, the bank figures. And then we said, okay, but we don't know the bank figures because you haven't given them to us yet. Well, you have to get them. So literally that dialogue, it took 3 extra days for finally the bank to send us their figures so we could put them on the CD to send them back to the bank with our figures and their figures on, for them to then change it a little bit and send it back to us and start the 3 days. But that particular bank was convinced that the settlement agent had to put the bank's figures on the CD to start. So we get surprised all the time with TRID and all the different let's see. Homeowners insurance. I always tell people, I teach a seminar for first-time home buyers for Piedmont Housing, and this is what I always tell them is, go shop homeowners insurance because you're going to pay that every year, but also shop your car insurance when you're doing it, because you'll get a discount typically from that if you got it both at the same company. And since you're going to pay that annually, and since rates are so over the ballpark, I used to be able to kind of guesstimate what insurance premium would be in, $100, $150. I have no clue anymore. They're just all over the waterfront. You got these farm bureaus who have these special deals, and there's all kinds of different things out there. So to definitely shop homeowners insurance when they're in car insurance together is a good tip to tell your buyer. keep in contact with all of us. I think we're all getting better about that. Like in my office, we share, any kind of email that we think the realtor needs to know, we're going to include them in it. Like, for example, if we're doing a fiscal survey, we're going to send you the survey too, because we have no clue if it's right. The survey's right, and y'all have been to the property a couple times. We'll send it to the buyer also. We want to include the realtor because we can do things wrong. I remember one case where the contract was written, it's a tax map number, that's all it was. Turns out there were two similar tax maps, and the listing agent and everybody else got the wrong tax map. They were side by side. The survey came back of a raw piece of land.
Well, oftentimes the tax maps are drawn inaccurately too.
Well, they always are drawn inaccurately.
It's a drawing that they keep.
Yeah, but again, it was that was the only legal description that was given, and when you go to the whatever county it was, the website, it would say what they owned. They had it wrong too, so everybody had the wrong tax map number, thinking that's where the house was, and it turned out the surveyor, he should have. I mean, obviously the surveyor would have been nice to call us and say, wait a minute, there's no house here. I mean, it got fixed, but it can definitely happen, and sending it to you guys help another set of eyes to catch something. When you have a survey, I think we did this in one of our earlier talks, and you've got especially a city or a subdivision lot that's been around a long time, and you've got a fence. The likelihood that fence is on the line is not very likely. It's pretty rare that a fence is on the line.
And most times, country property, they put them 1 foot inside their property so that they don't have to share maintenance. That becomes their maintenance issue as opposed to the adjoining property owner's maintenance issue. If it's on the line, supposedly you're supposed to share the maintenance.
Well, the way that works is, I don't think they purposely put it 1 foot on the line because they're all over the property line. But in order to have a common shared fence, the law in Virginia, which requires both people to maintain it, is there has to be some kind of an agreement to do that. Just putting it on the line doesn't create the duty of the other guy to maintain it. The case law says, we're not sure that's what the intended was. There's a recent case that, if I remember right, I think it was a Supreme Court case, it might have been a circuit court case. The fence, one person put a fence up, and then it was an old fence, and now he's going to replace it, and he says to the neighbor, well, I'm replacing the fence that was on the line, so therefore you've agreed to maintain it, and I'm going to put a new fence up, $30,000, can you send me $15,000, please? And the court ruled no, because there's no agreement. I think there's even something about sending a notice 30 days in advance, but even then what the court said was there are 4 other boundary lines, and several of those had no fences, so we believe that this owner never intended to fence in his land because he's got other boundaries that don't have fences. So we're not going to allow, say there's a common duty to maintain. That very rarely happens, the common duty to maintain. And most times the fences are, again, not on the line, especially like in city lots that they get off a couple of feet. So what do you advise your buyer and your seller? What should you do? You bought this property, you discover that the fence is 2 feet inside the line. Do you go to the seller and say to the seller, you need to go move the fence 2 feet over to the neighbor? So it's on the line? Well, if you do that, you've now got a neighbor that's going to hate you when you move in. So what do you do? I mean, there's some lawyers who will, make you go deal with that, which I think is a mistake. But legally, they have a right to do that. And I used to look at it practically, and I'll say, look, when you bought this property, when it got listed, everybody thought the fence was on the line. You didn't know you owned those 2 feet. Do you really want to fight over those 2 feet that you just now discovered you own?
We had neighbors that made us move our railroad ties 4 inches.
Yeah.
Jesus.
So how do you, let's just say you go that route, how do you protect yourself when you go sell it?
Well, you've got the doctrine of adverse possession.
Right.
And adverse possession means that it has to be there 15 years. It has to be open, notorious, and continuous for 15 years. So if this fence is not 15 years old, the new owner, or you can get the seller to send a letter to the buyer, to the next door neighbor called permissive use letter, allowing, I'm giving you permission to have the fence there. So it's no longer hostile. I'm giving you
The
permission.
other way, the neighbor would write that
Well, whoever,
letter. I
yeah,
mean, the new buyer would write it to the
to the neighbor,
to the
right.
neighbor saying,
And when I
look,
was
I know
saying,
you've got 2 feet, but I'm not.
yeah, I'm not gonna worry about
And
it.
then ultimately, would you do like a quick claim deed for those 2 feet, or what would you do?
Yeah, because then you gotta go do a boundary line adjustment, you got mortgages to deal with,
Right.
so it's not worth it.
So,
You're just giving them a license,
So
like
you're-
a unwritten
so-
license, it's a license.
so basically, if people are operating under the assumption that the fence line is the property line.
It happens all, when
I mean,
you.
that's what Bill's saying, is that when they, when they walk the property and bought the house, they're thinking that's the property line, but then they find that there's 2 feet more.
Right.
There's some attorneys that would be adversarial about that and say, you need to go fight for your 2 feet, you need to go make them move it. What Bill's saying is, hey, this is what you thought it was, so just write something saying that it's 2 feet over here and that you're fine with them using it. And then.
Or if you have a legal survey though, doesn't that, like,
Well, no, it's clear that the fence is in the wrong spot. But that's what I'm trying to say, fences are very rarely put on property.
right? Yeah.
Out in the county, on a big farm property, or even in a little quarter-acre lot in the city. Or even Forest Lakes, everybody out in that. They're just all over the place.
I've had that many times. It was tied, I had one downtown, tied up a closing fair. The attorney for the purchaser insisted that the fence and the shed were not on the prop, were encroaching on the neighbor's shed and fence were encroaching. We fought. The
Well, I
neighbor
can
got a
see
lawyer.
that, if you
We
think
have a
that
lawyer.
something is on somebody else's property, that problem I can see, but if you have your fence that's inside the property line, and then somebody's gonna make you move it.
No, with the neighbor is now using 2 feet of your
Your
land.
land,
You have an
okay.
extra 2 feet of land that you didn't know you had, but they're yours. They're yours
Right.
that you were contracted to buy. You contracted to buy that. Not what's inside the fence, but what the legal description is, which included those 2 feet. But let's do the opposite. Let's say it was the neighbor's fence that was 2 feet over. Or his garage encroached.
Right.
It's the same, it's the same problem. You're now gonna tell the neighbor, move your shed, and if it's a movable shed, that can be done, but now you're gonna tell the neighbor, move your feet over, your fence over. Again, you're now gonna have the neighbor from hell. Because you're gonna be considered the neighbor from hell, even if you blame it on the lawyer. So you just gotta figure out, what makes sense. And again, when you bought it, you thought that was your right. You didn't know that that you're not the line. It's an interesting thing, and like your problem, it can go on forever, or we can kind of come up with a practical solution that does everybody good. I always tell the neighbor who's going to deliver that letter, if you want, we can write the letter. But probably the easiest thing is after you moved in, when you got to know your neighbor, you'd say, I got the funniest thing to tell you. And you show them the survey and say, hey, my lawyer wanted to write this letter, so here it is. I give you permission.
Put the onus on the seller when they first decide to sell the property. Where are the property lines? Where are the 4 corners?
They very few sellers are going to go survey them.
They got no clue most of the time.
But again, if you go to the seller and say, hey, you got to fix it, they're going to fix it with the neighbor, and you're now going to move in with the neighbor's not happy. But some people want to fight about that. We'll certainly do it. But again, that's why I think surveys are important, because then everybody knows We're gonna, I think Tucker's took a hiatus over the summer. I think it's gonna come back, and this will be like a series of 5 or 6 survey tips, talking about a lot of stuff on surveys, because I think that's important. Try to finish this one. Number 8. This is so important. Make sure that whoever's representing your buyer, in this case, this is for buyers, make sure they get all the addendums. You'll be amazed the number of times we don't get the addendum about the agreed repairs and the closing costs. Now we've agreed on, no, there are no repairs, we've accepted the property, but there's a $3,000 closing cost credit. The lender got it, but a lot of times the attorneys don't know about it. We'll go prepare stuff and we'll be surprised at the end because there's $3,000 credit supposed to be given. So make sure you get those addendums to all the players. Off the record, sometimes you don't want the bank to have those. Sometimes when you have those repairs and you're going to have the buyer do something or the seller do something outside of closing, you may not want the lender to have it. You're supposed to let the lender have it. But
I've heard Jay say he'd rather not.
yeah, I mean, he doesn't want it. You know, because you think about it, as a practical point, the lender thinks the house is perfect. They don't want to know that there's a $3,000, roof that's got to be repaired, or the HVAC's got $1,500 worth of repairs to the bank. So how do you do that and still, walk the line? It's a tough one.
So I have a client that I'm representing, they're using you.
Uh-oh.
So I send you the addendum, and then am I also responsible for sending the other closing attorney the addendum, or is that the other agent's
The other
responsibility?
agent should do that. Correct. Yeah. Just make sure we have it.
But it is important to make sure it's in our folder too, because that's the other thing, is
Right,
we'll get the original package from everybody, but then there's a HERCA or whatever, and oftentimes that doesn't get into the original file, it needs to be there, as well as, and Bill, you can speak to this as well, everybody makes a deal, and they're gonna pay for a home warranty in lieu of repairs or whatever, but nobody knows that until you get to closing. Oh, by the way, the agents have agreed to, contribute $200 and the seller's gonna, and that didn't happen until closing because nobody thought about it. They worked it out. There was a $1,000 delta and everybody worked it out, however they worked it out. But how many times, I mean, a pretty large percent that everybody's gotta go scrambling back and changing something because that never got to the two attorneys.
So that on the commission disbursement sheet,
That's
is
right.
that adequate?
That's
Yeah,
exactly.
well, that and get us the addendum. Yeah, so most of the time when you guys are doing these addendums with repairs, you do it in lieu of closing costs for the warranty, and those are all kosher. But let's say you've got a situation where you've got a $3,000 repair that needs to be done, and you've already used up all the closing cost credit. That becomes a problem, because you don't want to have an addendum that the lender gets that says we're getting a $3,000 credit for repairs. Because then that just raises, the lender doesn't want that, Jay doesn't want that.
Jada, but I ran into I just had a closing a couple of weeks ago where I ran into a problem, and I couldn't understand it with the lender. The lender was insisting that I provide him all the documentation from the repairs addendum. Here, and I stated to the lender, and I said, look, we had a removal of a home inspection contingency addendum signed by everybody. Here it is, you had it for a while, and I said to him, look, this is all you need. You don't need anything else from me. What do you care? And what does your lender care? I've never heard this before, I said to the guy. I've never heard this. You're holding up a closing because you're waiting for documentation from me saying that all 10 steps in the repairs addendum has been complete and to the satisfaction of the purchaser. And the documentation, the supporting documentation, you want that too. And I said, you're holding up, we're a week late on closing because you're waiting for me to give you that? I said, what do you care? You have the removal of the home inspection contingency.
Well,
That's all you should care about.
Did they Did that, I mean, again, it's that lender. You could have said, well, I'll go to another lender.
Well, we had already gotten, we're way.
Well, again, what happens with, I call it the new four-letter dirty word in real estate, the underwriter.
Oh my God, I hate him.
And so, and different lenders have different policies. So my guess is, first of all, did the inspection ever go to the lender?
Home inspector?
Home inspection?
No.
Okay, but the agreed repairs addendum went to the lender, and it had all the different items.
Yes.
It had, and you said.
It had a removal of the.
But
home
did you
inspection
send out the lender, get the one that goes through, I want these 10 items fixed, I agree to do that? Is that the one they got, or did they get the agreed repairs again, and the one at the end that says, we've accepted it, this is what we
Sorry,
decided?
one on the same.
They were one and the same.
I thought there was one that you didn't have, that doesn't show the back and forth.
I know, it's not.
No,
Okay.
there's simply one form that says the removal of the home inspection contingency and blah, 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 blah. This is
So with that lender in the future, I would only send them that form with the last section, and I'd redo that form that only shows what the conclusion was. Because that lender, somewhere the underwriter said, we've got all these repairs, we want to make sure they were done. And that particular lender.
He kept saying this, we need documentation from you removing the home inspection contingency. I said, you have it.
And they wanted to see what got done to fix it, because they were worried about their canal.
And
But that's an unusual.
Who asked for that?
The
lender?
Which
The
lender?
lender.
Which
The
lender?
lender used that as the excuse that he could not get the CD in time to close, and it was a week late because the
They wanted that.
purchaser's agent didn't bother.
Well, go ahead and tell us who that lender was.
Pilot mortgage.
Yeah.
So,
There's probably other things going on there. Was there one, did I do the closing?
no,
Okay. Good. I do some.
oh, no, because the purchaser was a paralegal for Jim Cox.
Oh.
Jim Cox did the closing, Jim never said a word. Jim didn't.
Well, anyway, different lenders, underwriters, just got to deal with it. Figure out how to work around. Let me just finish this one, and then we'll say the next few places. We got contract, commission statements, number 9, and have that note in there about the warranty, whatever, or I want to be reimbursed the $200 I paid to have the yard mowed, whatever you need to let us know it. And that commission statement's a great place because we look for it. We take that as the gospel of how money's to be divided. Sometimes we'll get them from both sides if we represent the seller. But you as the buyer's agent want to make sure your attorney gets it. And you probably, because the seller's the one paying commission, want to get it to the seller's agent too, the settlement agent. So you want to get to both sides, but okay. Number 10, that's, the cash, the CD that comes out 3 days before sometimes can be tweaked a little bit. And the cash is typically the same number, but it can change a little bit. We usually take a personal check for that or refund money. Wires, number 11, nobody deals with certified checks anymore, cashier's checks. It's always going to be a bank wire.
I was surprised the other day, I was on Thursday last week, that I didn't get, with the 8 buyer's agent, I didn't get a copy of the CD prior to that, and I hadn't seen it, actually didn't get one as I left the office, and I didn't get one in the envelope that comes with the check. I had to email the president and say, can you send me a copy of the buyer's CD for our files?
You had the buyer or the seller.
I'm surprised that-
But again, that's part of it. What did they say? They just made a mistake, or they said, I get permission.
I'm sorry.
And again, it used to be that was what we talked about earlier, that there used to be some discussion that you can't give the CD to everybody. It's privileged information. And that's why we created it was a year ago or more, some addendum that said, I authorize the CD to deliver to whoever needs it. But pretty much now we're all decided we're going to deliver CDs to the realtors, to the other side if they need it, whatever needs to be done.
Well, what came in the envelope to Ann was the seller's copy.
Somebody made a
But
mistake.
not the buyer.
Clearly made a mistake. That happens. And that leads us to number 12. Don't blame anybody. Just, we gotta go fix it. Whatever it is, let's go fix it all together. If we start pointing, because there's so much that'll go wrong in the closing. So our position is, look, we may know that the lender screwed up your underwriting, whatever, with all this, but let's don't blame anybody. Let's just go fix the problem, because it doesn't really help a lot to point fingers. It's better to, let's just come together and figure out, tell us what's going on, and we'll figure out a way to solve it. Because everybody wants it to happen. The seller wants to sell, the buyer wants to buy, the lender wants to make a loan, realtors want to make commission, attorneys want to close the thing and get it out of their system. So we're all figuring out, let's make it work. So don't blame anybody, just deal with it. I always tell people attend the closing, but a lot of realtors don't. I think that's a really good learning experience to be at the closing, see what goes on. Sometimes you'll see something that we all missed, like, hey, where's the warranty? Oh, I forgot to have the warranty. Let's go deal with it. I mean, we had that happen not too infrequently, where we're at the closing table and all of a sudden somebody says, where's my warranty? Or something else. Delivery of keys. We do not have a hard and fast rule when keys get delivered to buyers. Remember, this is a tip for the buyer's realtor. So I would arrange ahead of time with the listing agent, what's the deal on the keys? Legally, it's not the buyer's property until the deed's recorded, which
Thank you, Jesus.
could be the next
Put that
day.
in your trucker's tips.
Well, I mean, most of us know that, but when do the keys go? When should you give the buyer the keys? If you're Southern Development, you're not going to get the keys till I can get my money, or till it's closed and recorded. One of my builders, unless we've wired them the money, they don't want the keys to go out. So different builders have different policies, but just the normal mom and pop buy and sale, resell something. There are no hard and fast rules typically, but legally you don't have to give them out till the end. But my practice advice is, if I'm sitting there representing a buyer and somebody asks me about the keys, I'll say to them, look, if the buyers come in and they signed all their loan docs and we don't have any other issues, and I know the bank's money's coming, and the buyer has either already delivered me their money or their money's coming, the buyer has nothing else to do but to wait till all the rest of the dominoes fall in place. The dominoes from that point on, we gotta have the bank's money, we gotta have the buyer's money, we gotta then send it to the seller's attorney, we have to go get the deed from the seller's attorney, and then we gotta go to court. So there are all these extra dominoes that the buyer has no control over. So if everything's pretty much equal, wouldn't have the keys then?
But can they have, I had this happen last week, that the buyers made it an earlier closing, and my seller was in like Shanghai or someplace ridiculous. And he wanted to close on Friday. I said, well, we can do that, except that I will warn you, it's got to be recorded on Friday because Monday is a holiday and you can't take possession of the home until it's recorded. Well, he had a fit and fell in after it. I mean, he was screaming and yelling.
The buyer?
The buyer. I will take possession when I sign the documents. I said, you're signing loan documents.
Yeah.
The permit. I mean, this guy could not, and he's like an international attorney or something, but he's obviously got an issue. But so how do you?
Who's an attorney? What do you expect?
Well, last week, we were gonna close at 2 in the afternoon on a Thursday, but they called from Charlottesville Sutherland and said, if you could do it in the morning, that would be more assured that you'd be able to get possession later.
Well, again, it's what is the seller saying about delivering the keys? Some sellers don't care.
Well, the seller should give them the keys,
Yeah.
but they cannot have possession of the home until it is recorded.
That's what the seller said.
Yes.
Well, that's different than giving them the keys. Normally, give the keys and they go move in.
Yeah.
And I don't have a problem with that because I know, my buyers got their insurance. I got their money or it's coming. I got the bank's money or it's coming. So it's just a matter of just the next steps. So why not let the buyer move in?
Well, the problem is that this was over a long weekend where you could not record until Tuesday morning.
So, you want to have, if you're coming up with one of those and you've got difficult people, maybe that's when you do one of these early possession agreements. The early possession agreements, by the way, that y'all have, we vetted them as lawyers, and we like those forms. They cover everything you need to cover. And there's the late possession by seller form, and there's the early possession by buyer form. And it can be limited, just put your stuff in, you can't spend it on. So you got all kinds of versions. So if you've got a seller who isn't gonna let them have possession, you can have the keys but not possession, and you got this long weekend coming up, maybe that's when the two realtors see if we can sign an early possession, where if you don't have your money by Tuesday, I'll start paying rent. Because I don't know if it happened on Friday or not.
It did happen on Friday because
You insisted.
I just worked quite hard to get it done.
Exactly.
You've got people that are sitting there,
One
again, you're solving problems.
of the things that I'm going to be proposing is an addendum, we did this in an early meeting, to y'all's contracts, is a settlement procedure addendum to the contract that talks about the way we do settlements. And so we have the out-of-town settlement agent trying to come in and close and do it a different way, or we just want everybody to know this is the process here. That addendum that I'm working on with the real estate bar that we meet monthly, I'm also going to have a section about the keys with the door.
Right.
With you check the box so everybody knows ahead of time when the keys are.
Well, I had actually seen it written in contracts recently that they won't be, the keys will not be delivered until.
And putting this addendum together may create that kind of problem. It may get people thinking about it, or now they don't think about it, they just hand the keys out. Bring the last two were number 14, make sure they bring some kind of photo ID. You're gonna have to make a copy of it. And then 15, by the most important, is you want to pick up the check from remember it's the seller's attorney's got the check, not the buyer's attorney. And you want to pick it up, have it mailed, make sure, when they get that commission statement, you're giving them instructions what you want to have done. Okay. Any other questions? Cool.
Thank you.
Save the next for next.
Thank you.
So I have to remember the witness, the buyers, when I think we're not making those.
Your initiative of the selling process.
Well, it's also nice because then you can just hand it to somebody. You don't have to go through the explanation, and they don't believe you.
Well, it needs to be in the contract, though. Agreed. And that's going to be the difficult part, is how to get it in the contract. Because if it's a separate addendum, it's a little harder. If we could, and again, different offices may not want to use it, but if it can get in, like Southern Development and one of the other builders has it already in there. So I sort of taken their version, modeled it a little bit. And so it's already in that contract, but we have a VAR form that comes out of Richmond, and so can you in fact, like some areas will have like a Northern Virginia addendum to a contract. They have their version. So I don't know how we're going to get it in your contracts. But.
Do you anticipate this being presented ultimately to VAR?
Well, the bar's already, real estate bar is already approved.
Virginia Association of Realtors to get it into available and check the box.
But our procedure is different than everybody else, so it's going to have to be a specialized VAR Central Virginia contract. And right now we haven't agreed. The real estate lawyers haven't agreed on the language about the keys, but so we're working through that. But then it'll be different offices where the guys decide to use it. Like the other one, nobody decided to use, but it worked itself out.
Be contentious.
And what'll happen is, I think what'll probably happen is if your agent is from out of the area, or you have a buyer or a seller that's out of the area, that's probably a trigger. Let's put this in the contract.
locally in terms of presumption.
If we-
Possession. And moving vans out there waiting, you know?
But I think the key thing would be interesting too, if we can make that.
That's.
Everybody have a good week.
Yeah, they do have to allow us. I'm sort of going to,
Oh, no, Rich, you can all over again.
yes. And I think it's there.
the